3, 2, 1, start. The law is developed on Order 7, Rule 11 of CPC to the extent that it becomes rather a duty of the court to invoke Order 7, Rule 11 and not to permit illusory cause of action to be precipitated any further, and in that context, the observation which have been made by yet another division bench of this court reported in 1998 (2) GLH H23 in the case of Maharaj Sri Manvendra Singh Ji Ranjit Singh Ji Jadeja versus Rajmata Vijay Kuwari Ben, daughter of late Maharaj Mahendra Singh Ji, contended in paragraph number 13, 14 and 15 deserve to be reproduced hereinafter. Para. Having noticed brief summary of the plaint and prayers earlier, it would be relevant to refer to the provisions of Order 7, Rule 11A of the CPC and the scope thereof. Order 7, Rule 11A of the CPC provides that the plaint shall be rejected in case where it does not disclose a cause of action. Order 7, Rule 11A of the CPC is mandatory, and if it is found that the plaint does not disclose a cause of action, the court has no option but to reject the plaint. To find out whether a plaint discloses a cause of action or not, the court has to look only to the amendments made in the plaint. When a plaint is based on a document filed along with the plaint, it can, however, be considered to ascertain if plaint disclose any cause of action. Cause of action means every fact which it would be necessary for the plaintiff to prove, if traversed, in order to support his right to judgment, The words cause of action mean the whole bundle of material facts which are necessary for the plaintiff to prove in order to entitle him to the reliefs claimed in the suit. What is to be done by the court at the stage of deciding as to whether the plaint discloses any cause of action or not is to find out from the allegation of the plaint itself as to whether a bogus, wholly vexatious or frivolous litigation is sought to be initiated under the garb of ingenious drafting of the plaint or not, because it is the duty of the court to guard against the mischief of litigant misusing the process of court by entertaining into a false litigation merely for the purpose of harassing the other party and to nip in the bud the litigation which is sham and shabby in character. In order to find out whether the plaint discloses a cause of action or not, the amendments made in the plaint and documents annexed thereto should be scrutinized meaningfully, and if on such scrutiny it is found that the plaint does not disclose cause of action, it has got to be rejected in view of the provisions of Order 7, Rule 11A of the CPC. When it is said that the court should take into consideration the amendments made in the plaint, for the purpose of deciding the question whether the amendment made in the plaint disclose cause of action or not, comma. It does not mean that the court is precluded from applying the statutory provisions or case law to the amendments made in the plaint, full stop. If an assertion made in the plaint is contrary to statutory law or cause law, comma, it cannot be considered as disclosing cause of action, full stop. In ITC Limited, comma, bank had filed suit against the appellant and others and claimed relief from a sum of rupees 52,59,639 pesos, full stop. After the suit was filed, comma, it was transferred to the Debt Recovery Tribunal, full stop. Before the tribunal, comma, an application was filed by the applicant under Order 7, Rule 11 of the CPC for rejecting the plaint, comma, so far as appellant was concerned, comma, on the ground that no valid cause of action had been shown against the appellant, full stop, para. That application was rejected by the tribunal, full stop. Against the said order, an appeal was filed before the Debt Recovery Appellate Tribunal, full stop. The appeal was dismissed in limine, full stop. Thereupon, a writ petition was filed by the appellant, comma, which was dismissed, holding that the question should be decided at the trial, full stop. Against that judgment, comma, the appellant had filed an appeal before the division bench of the High Court, comma, which was also dismissed, full stop. The matter was thereafter carried before the Supreme Court, full stop. After taking into consideration the decided cases on the point whether there was fraudulent movement of goods under which letter of credit was obtained, which in turn entitled the bank to file the suit, comma. The Supreme Court held that that point was already decided by decision of the Supreme Court in UP Cooperative Federation's case, and therefore the allegation of non-supply of goods by the seller to the buyers did not by itself amount, comma, in law, comma, to a plea of fraud as understood in this branch of the law, and hence by merely characterizing alleged non-movement of goods as fraud, comma, the bank was not entitled to claim that there was a cause of action based on fraud or misrepresentation, full stop, while allowing the appeal, comma. What is emphasized by the Supreme Court is that the question whether a real cause of action has been set out in the plaint or something purely illusory has been stated with a view to get out of Order 7, Rule 11 of the CPC has to be decided with refer to the amendment made in the plaint, and clever drafting creating illusions of cause of action are not permitted in law, and clear right to sue should be shown in the plaint, full stop. In view of this decision of the Supreme Court, comma, it is evident that if something purely illusory has been stated with a view to get out of Order 7, Rule 11 of the CPC by resorting to clever drafting, comma, it cannot be said that the plaint discloses a cause of action, and if a clear right to sue is not shown in the plaint, comma, it is liable to be rejected, full stop.